Your Honor, may I reserve 2 minutes for rebuttal?
Yes.
Chief Justice, Associate Justices, and may it please the Court, my name is Heather Jacobs, and along with my co-counsel, Sarah Colley, we represent the petitioner, Ms. Andrea Somerville. Would Your Honor like a brief recitation of the facts?
No.
The issue before the Court today is whether Olympus State University School of Law's preferential admissions policy violates the Equal Protection Clause of the 14th Amendment. The policy violates the Equal Protection Clause for 2 reasons. First, gender is an immutable characteristic, and therefore gender-based discrimination in higher education academic admissions should be treated as inherently suspect, and the principles of strict scrutiny should be applied. Second, there is not adequate evidence provided that this admissions policy remedies the actual issue of gender imbalance in the law school. As put forward in the plurality opinion found in Frontiero v. Richardson, brought before this Court in 1973, classifications based upon sex, like classifications based upon race, alienage, and national origin, are inherently suspect and must therefore be subjected to close judicial scrutiny. Focusing on the aspects of gender discrimination in higher education admissions policy, an immutable characteristic is any sort of physical attribute which is entrenched and innate. Frontiero notes that it can hardly be doubted that, in part because of the high visibility of the sex characteristic, women still face pervasive, although at times more subtle, discrimination in our educational institutions. This policy put forward by the law school illustrates the subtle shape this discrimination can take in our educational institutions. As cited in Frontiero and found in Reed v. Reed, the challenge statute provided similar treatment for men and women who are similarly situated. Men and women are similarly situated in the instance of higher education admissions. However, the law school also concedes that it let in less qualified male candidates, but all female candidates had the same or higher qualifications.
You mentioned earlier that you think strict scrutiny should be applied because of immutable characteristics, true? So, but I'm looking at Michael M. versus Superior Court of Sonoma County, and it's expressly declined to apply strict scrutiny as gender classifications are not inherently suspect. How do you compare that case with the present case?
The present case, men and women are similarly situated in the instance of higher education admissions, which is different from the Michael M. versus Superior Court case. I would also like to note that in U.S. versus Virginia, Justice Ginsburg does note that the 14th Amendment is not a group classification law. It has to be applied on an individual basis, and in this case, Ms. Somerville is similarly situated to her male colleagues that we're also applying. Okay. The way the law school gives to gender, because all women who were accepted had to have the same or higher hard variables that Ms. Somerville had, would seem to supersede all other qualifications and lowers the expectations for males in a way it does not for females, which places an undue burden on females that is not shared by males. In 1978, the court delivered a plurality opinion in Regents of the University of California v. Bakke, in which they stated the petitioner has conceded that it could not carry its burden of proving that, but for the existence of its unlawful special admissions program, respondent still would not have been admitted. The law school has already conceded that had Ms. Somerville been a man, she would have been admitted into the law school. This means that for her case, gender was ultimately the deciding factor for her getting in. This brings me to my second point. The law school fails to provide evidence that the policy is substantially related to the issue the law school is trying to remedy. In the 1988 one case, Michael M. versus Superior Court of Sonoma County, the opinion states that the state could have achieved the same objectives through a law that does not distinguish between male and female teenagers. While the law school has explored other options, the policy does not address the underlying issue that the university has.
Isn't the underlying policy or the goal to have about 48%, whatever, somewhere in there, gender?
As stated in
Balance.
Gender balance, thank you.
Your Honor, as stated in Grutter, all that's necessary is a critical mass. Then reaching for a specific percentage is not constitutional. And we believe that a critical mass has already been reached. 38% men means there are enough men in each class that they don't feel that they have to.
So is this a disagreement? Is there a disagreement about what number is critical mass?
There's not a disagreement because there's not a hard number. In fact, I believe that the only thing that has been stated is that the critical mass just means that the minority has to feel like they don't have to represent their group. And since there are 38% of males, they certainly don't have to represent their group in classes.
If you believe that strict scrutiny is the correct standard to apply, then why doesn't the Grutter v. Bollinger, decide this case? It was a considering race as a factor in student admissions, and so it applied strict scrutiny, and it found that it was narrowly tailored because it took a holistic review of each applicant's file, which is the case here, isn't it?
Indeed, Your Honor, but as mentioned in my first point, the way the law school has structured the plus-minus factor in their admissions policy, it gives a higher, gender is counted as a higher plus than virtually any other soft variable. If you note in the record, the LSAT scores and GPAs of women admitted were at the level or higher than Miss Somerville. There were no women admitted that were lower than Miss Somerville. However, the men that were admitted were lower. There were men that were admitted that were lower. And unless we are going to contend that all the soft variables that women had were less than all the men's, which seems implausible, we would ask that this court consider the plus-minus factors that the law school is using as unconstitutional.
Didn't the OSU admissions, didn't they state in the record that the men who had lower scores also had other plus factors like came from impoverished backgrounds, had unique life experiences that made them more valuable as a student body?
Indeed, Your Honor. And what I was trying to say was that we can't assume that those variables don't apply to women as well. There are women from impoverished backgrounds. There are women who are single mothers. There are women who have had similar soft variables to men who were not let in with lower GPAs or LSAT scores to Miss Andrea Somerville.
Is there a predetermined bonus that OSU uses as a plus factor?
I don't believe one is stated in the record.
They don't have a quota, do they?
Not a hard quota, but as I stated, they're just looking for a critical mass, which has already been reached.
And is that the distinguishing characteristic between Grutter v. Bollinger in this case, that critical mass has already been attained?
Yes, sir. Yes, Your Honor. And also of note, the law school's problem is not that they aren't admitting enough male applicants. The law school's problem is that they aren't getting enough male applicants to apply. And this solution can never be a remedy for that problem without placing an undue burdens on female applicants for the reasons previously stated.
Are there other options they could employ other than this plus factor in admissions?
Your Honor, it does show in the record that they did attempt others options, but yes, Your Honor, we do believe that there is more that they could have done. And it is for these reasons that we ask this court to overturn the decision of the lower courts and declare this policy a violation of the 14th Amendment.
Chief Justice, Associate Justice, and may it please the Court. My name is Sarah Colley, and along with my co-counsel, Ms. Jacobs, we rise on behalf of the petitioner, Ms. Somerville, in the case of Barr. I will be continuing my co-counsel's argument by transitioning into the First Amendment component of this case. The issue before this Court today is whether or not OSU University violated Ms. Somerville's rights to freedom of expression when they fired her for a poem that she read aloud at a university-approved event, Unity Fest. We contend that OSU University did violate Ms. Somerville's rights for two key reasons. In accordance with the Connick-Pickering balancing test, Ms. Somerville was first, speaking on a matter of public concern as a citizen, and second, the interest that she has in engaging in this speech outweighs any interest that OSU University may have in regulating it. As stated within Roth versus United States, cited within Connick versus Myers, the First Amendment was created to assure the unfettered interchange of ideas that would bring about the political and social changes desired by the people of the United States. This is exactly what Ms. Somerville's speech aims to do in the case of Barr, Your Honors. The Connick-Pickering balancing test, refining the original 1968 Pickering balancing test, aims at striking a balance between public employee speech in commenting upon matters of public concern and the interest of a state in maintaining and operating an efficient place of business. We can clearly see that there are two guiding inquiries within the first prong. The first guiding inquiry is whether or not this is a matter of public concern. To analyze what is a matter of public concern, I'd like to turn this Court's attention to Connick versus Myers. Connick versus Myers stated that analyzing the political and social implications of the speech in question must be determined to see if it's a matter of public concern. We can clearly see that the speech that Ms. Somerville engaged in, the poem, as seen in Appendix 1 of the record, clearly aims to discuss the political and social implications of affirmative action and gender inequality that has plagued this country for decades. Furthermore, as stated in Rankin versus McPherson, to determine what is a matter of public concern is to analyze the speech, or the context, and form of the speech as revealed by the whole record. As revealed by the whole record is the key in determining this, Your Honors. We can clearly see that OSU University is a systematically misogynist entity, and this systematic misogynist sentiment has trickled down into a toxic campus culture. There has been hate crimes running rampant throughout campus. There is racism, anti-Semitism, and sexism that has plagued OSU's campus, and Ms. Somerville found that it was her moral duty to speak out about this as a citizen.
Was she speaking as a citizen, though, or was she speaking as an employee?
Yes, Your Honor, that leads to the second guiding inquiry within the first prong. She is speaking as a citizen, because this Court in the case of Pickering versus Board of Education—
But what about the fact that she was criticizing her employer and her employer's policies?
Your Honor, she's speaking as a citizen. To answer both of your questions, Your Honor, she's speaking as a citizen not because she's criticizing a policy adopted by her employer, but mainly because she applied to the law school as a citizen. She did not apply to the law school as a lecturer within the Women and Gender Studies Department. And her 14th Amendment rights, as already addressed by my co-counsel, were egregiously violated as a citizen. Therefore, she has the right, the constitutional right, to speak out about this issue as a citizen on the public platform of Unity Fest.
But the public platform, Unity Fest, she stood up and said, "I'm a lecturer here at OSU." Did she not?
Yes, Your Honor. Page 7 and 8 of the record does indicate that she addressed herself as a lecturer. However, we contend that she's only doing that for credibility measures. Page 8 of the record indicates that she did still have a platform to address her concerns as a citizen, because the specific platform of Unity Fest was not only open to students and employees, but to the general public. That's why she had the platform to speak out about a matter of public concern.
Were her students in the crowd?
Yes, Your Honor. Footnote 13 of the record indicates that one of her former students, Sydney Kirsch, introduced her on the platform of Unity Fest. However, she is still speaking out about this matter as a citizen, even though the subject matter is related to what she's an expert in the Women and Gender Studies Department. This leads me to my second point, analyzing the specific effects that the speech had in relation to the state's interest. We are not denying the fact that OSU University has a vested interest in maintaining an efficient operation, an efficient place of business in the university. However, the key to determining who has the greater interest is examining if the consequences of the speech that Ms. Somerville engaged in directly hindered OSU's ability to function. Quite simply, Your Honors, nowhere in the record does it indicate that the speech that Somerville engaged in directly caused OSU to not be able to function as an institution of higher education.
What about the state's interest in diversity? Did it hinder the state's interest in diversity?
Your Honor, the record does indicate that there was a 20% drop in applications despite race or despite gender. There was a specific 20% drop in men applying to the university. However, I would like to turn your attention to page 4, footnote 4 of the record, where as reported by the United States Department of Education, 83% of U.S. colleges in the United States have a majority female campus, and the whole reason this policy was adopted, as was previously addressed by my co-counsel, was to already remedy this issue, so we cannot in full faith say that the specific speech that Ms. Somerville engaged in had a direct effect on the 20% drop in applications. And even if it did, as held by this court in Rankin versus McPherson, the fact that speech is controversial still has constitutional protections. We are urging this court to view it as such. Even if this court regarded her in her capacity as an employee, I would like to turn this court's attention to the lower courts, where they are trending towards expanding the realm of academic freedom and the meaning of academic freedom to include university professors. As is seen in Adams versus Trustees of North Carolina and Wilmington, the Fourth Circuit acknowledged that that university professor had the right to speak out about a matter of public concern and viewed that the specific issues that he was discussing was indeed constitutionally protected, even stating that after the First Amendment speech was given or engaged in, the speech is not converted into unprotected speech when other factors come into play after the speech is made. Furthermore, in Demers versus Austin, the Ninth Circuit held that protected academic writing is not confined to scholarship. In academia, people write different types of documents addressing a variety of different things. In this case, a professor wrote a document called The Plan, made by the professor, that made broad proposals to change the direction and focus of the school. It is essential that this court understand that they were using the Pickering balancing test when determining whether or not they were granted constitutional protection.
But in that case where the professor wrote about changing procedures in their school, did that have any kind of detrimental effect like what we see here?
Your Honor, the record indicates in those cases that there was a slight detrimental effect within the classroom environment. However, the court still sided in favor of the professor and expanded the meaning of academic freedom, because in the cases of universities in the realm of academia, we cannot in full faith apply the restricting analysis of cases such as Garcetti v. Ceballos or Connick versus Myers. We must employ a balancing test, whether or not it's the Pickering balancing test in the lower courts or the refined Connick-Pickering balancing test in viewing her statements made as a public citizen on a matter of public concern.
What about the fact that her speech was on campus? Does that matter?
Yes, Your Honor, it does. However, we would still employ the Pickering balancing test, because in the case of Pickering, the statements that the teacher still made were related to the school matters, were related to school issues that were taking place on campus, and this court still held that he had constitutional protections in engaging in those speech. The guiding inquiry is whether or not that speech outweighs the interests of the university, and we can clearly see that although there was some effect, that effect has not been detrimental. And to the point that this court and opposing counsel's burden is to prove that that specific effect that the speech resulted in crippled the complete efficiency of OSU University.
Weren't there other detrimental effects, like the deterioration of the environment on campus and gender tension?
Your Honor, respectfully, page 7 of the record indicates that this has been taking place for over 5 years. Ms. Somerville's speech merely addressed it. That's why it is a matter of public concern, and that's why OSU University held the specific platform of Unity Fest. This is a matter of public concern, Your Honors, and it is essential that this court side in favor of the petitioner and view it as such. And the day that we put monetary interest and economic gain above one's precious constitutional rights to address these matters is a dark day for this court and its constitutional jurisprudence. It is for these reasons that we urge you to side in favor of the petitioner and reverse the ruling of the 14th Circuit Court of Appeals. Thank you. Associate Justices, and may it please the Court. My name is Danielle Davenport, and I, along with my co-counsel, Mr. Jeremy Fernando, will be representing the state of Olympus in the case of Barr. I will address the 14th Amendment component of this case, and my co-counsel will address the First Amendment component. The issue before the Court today is whether OSU's admissions policy, which grants preferential weight to male applicants, is a violation of the 14th Amendment's Equal Protection Clause of the United States Constitution. Before I begin, I would like to bring up one point made by opposing counsel. Opposing counsel contends that the proper standard of review in the case of Barr is strict scrutiny, but we disagree. We'd like to turn this Court's attention to the case of Craig v. Boren, as cited within the case of Kirchberg versus Gamstra, in which there was an Oklahoma drinking law that permitted women to buy alcohol at a younger age than men. A group of men challenged this law and said that it was discriminatory, and the Court agreed. Out of this court case in the 1970s, the Court created intermediate scrutiny specifically for gender-based classifications. The Court said that they needed a standard of review that was higher than rational basis, but also lower than strict scrutiny. They needed a test for elements that were quasi-suspect, since they already had strict scrutiny for classifications that were inherently suspect. Because in gender-based classifications, there are times where men and women are not similarly situated. This is what makes gender-based classifications quasi-suspect and not inherently suspect. Moreover, Your Honors, OSU's admissions policy is not a violation of the 14th Amendment for two key reasons. First, the policy does further an important governmental interest, and the policy is substantially related to achieving that interest. Second, if OSU is forced to reconsider Ms. Somerville's application, that would be a violation of their academic freedom. Your Honors.
The university's academic freedom
Yes, Your Honor.
of admitting people they want to admit?
Yes, Your Honor. To answer your question, I'd like to direct you to the case of Sweezy versus New Hampshire, as cited within the case of Regents of California versus Bakke, in which the Court said that universities have 4 essential freedoms. First, to determine for itself the academic grounds for who may teach, what may be taught, how it shall be taught, and who may be admitted. So asking them and forcing them to reconsider an application would violate this academic freedom that the university does have.
That freedom has constitutional constraints, does it not? They can't only admit white people, for example.
Yes, Your Honor. Although universities do have academic freedom, it does not give them the right to violate the Constitution. And in the case of Barr, the policy is not a violation of the Constitution. It's not a violation of the 14th Amendment, so there would be no other constitutional violations. So their academic freedom still holds.
Doesn't even the lower intermediate scrutiny that you're suggesting that we use, doesn't it still have to have exceedingly persuasive justification for the challenge classification?
Yes, Your Honor. In the case of Wynn versus INS, the Court does talk about exceedingly persuasive justification. We see that they have met the threshold of exceedingly persuasive justification. They are trying to remedy a gender issue within their law school. Page 5 of the record indicates that they are trying to break down the stereotypes that exist within the school. Because there are gender stereotypes and biases that have built up over time, they're trying to remedy this within their law school. They also think that by creating this policy, they are going to bring more diversity within the school in regards to analytical approaches, life experiences, things that benefit the school, things that benefit the students, things that benefit American society in general.
Wasn't OSU male-dominated up until 1970?
Yes, Your Honor. Although
Did it have affirmative action for women in 1970 and before?
Your Honor, although OSU did not have any, it is true that it was male-dominated, just like many other places of higher education and lower education have been.
I guess my question is if diversity is their interest and the reason they have this policy now, why was diversity not an interest before 1970 when we had the opposite problem?
Yes, Your Honor. Though I cannot speak for the school at the present time of why that was their decision, there has been a history in the United States of discrimination against women that is egregious. We do not want this to happen again. And the school is trying to take measures into consideration in which they will prevent things like that from happening again. The record indicates on page 4 that the law school the percentage, the gender balance within the school had even dipped so low as to men being 20% of the population. This is 80 to 20 is a pretty big difference. And so if we see that trend continue, then the school will be female dominated. And in a sense, there's nothing necessarily wrong with either gender, but you also want the school to promote a top quality education. These students need different analytical approaches to be heard. They need to be able to interact with people of the other gender so that when they do go out into the workforce, there's fluidity between the genders. They need these different types of thinking skills, analytical approaches, and experiences all within the university. The university has recognized that this terrible discrimination that's happened against women in the past, and we definitely do not want that to happen again, and we don't want that to happen with any group of people. So promoting diversity within the school is a really important interest. And this court has also held that not only is diversity an important governmental interest, but it's also a compelling one. So even if you did apply the strict scrutiny prong of compelling interest, that would still meet the threshold.
Why shouldn't we follow the precedent in the United States versus Virginia, where even under the lower standard, it was found to be unconstitutional to discriminate based on gender?
Yes, Your Honor. We would like to point out that in the case of United States versus Virginia, that this was in a case using intermediate scrutiny. They did not use strict scrutiny. So petitioner uses this in their argument, but this isn't intermediate. This is a case that was used with intermediate scrutiny as the test and the standard in that case. So with VMI, there was an issue with the school not accepting females into it. We see that this could be similar to OSU if we do not, but in the reverse. It could be similar to OSU in that men could be, or women could be the dominant gender within the school, and not having any males in the school eventually, like leading to that would be similar to what we see in VMI, if that makes sense. Does that answer your question?
Well, if we followed United States versus Virginia, wouldn't we strike down this policy?
No, Your Honor, because this isn't necessarily a policy that's only, just because it has preferential weight to males doesn't mean it's excluding women from the application pool. Petitioner does indicate that there were some men that got in that had lower scores than Miss Somerville, but there's actually no evidence in the record at all that states that there was a qualified female applicant that was denied over a male who scored lower than her on GPA and LSATs or other variables. So there's no actual indication of them limiting women necessarily going into the school. There were plenty of women that got accepted to the school. It's not like they were rejecting any women that came in. The women
What about the fact that the school admitted that if she had been a man with the same qualifications, that she would have been admitted?
Yes, Your Honor. Page 6 of the record does indicate that the law school concedes that had she been a man, she would have been accepted. But this doesn't mean that the admissions policy is unconstitutional. The way that the law school sets up its admissions policy is similar to what we see in the law school of the University of Texas Law School, and as well as the law school in the regions of California versus Bakke. We see that these both use plus systems, and these plus systems were perfectly constitutional. And quoting Bakke, these are both constitutional using plus factors if it does not insulate the individual from comparison with all other candidates for available seats. We see that Miss Somerville had a GPA of 3.5, and her LSAT score was a 159, so she was around the 77th percentile of applicants, so she fell below average in her application, the admissions process. So she wasn't any kind of outstanding applicant, but she was measured with people in her same situation, in which they had similar soft and hard variables as her. And so just because they give gender weight as a soft variable, it doesn't mean that it was the deciding factor. They didn't say just because she's a female, we're not going to holistically review her and we're going to reject her, but the record does indicate that they did review her holistically, and gender was the one factor, the one small factor within a factor that tipped the balance in somebody else's favor that was not hers. And it is for these reasons that we ask you to affirm the ruling of the lower court and to deem OSU's admissions policy as perfectly constitutional.
Thank you. Go ahead.
Honorable Chief Justice, Associate Justices, and may it please the court. My name is Jeremy Fernando, and I rise today along with my co-counsel, Ms. Danielle Davenport, on behalf of the respondent, Olympus State University, in the case of Barr. Turning this court's attention to the First Amendment violation, the question before us today is whether petitioner's repeated remarks over a matter of personal interest that disrupt the full effectiveness of her place of work are protected speech under the First Amendment. First Amendment is a powerful tool to the essential and to the well-being of our society. However, when taken for granted, freedom of speech can cause businesses to fail. Therefore, today we have before this court, we have a citizen who dragged her own personal conflicts into her own classroom, which eventually caused the disruptive effect on the university. Therefore, we ask this court to affirm the ruling of the lower court in finding that Ms. Somerville's speech is not protected under the First Amendment for the following two reasons.
I'm sorry, so you said that she brought her own personal issues into the classroom, wasn't she just being relevant to her students?
Respectfully, no, Your Honor. As we can see, Ms. Somerville is a Whigs professor, and this case solely depends on speech related to her employment duties. And based on the record, we can see that Ms. Somerville did not bring about her case into the public until after she was denied by Olympus State University. Therefore, we don't see this as necessarily it is public concern, but we see this the way that she brought it out, more of a matter of personal grievance. And this court today—
Counselor, real quick, earlier you said that when taken for granted, freedom of speech can cause businesses to fail. I thought that was an interesting statement. I'm curious, was it her actual speech that caused the problems on this university, or was it the exposure of their own policies that caused their problems?
Respectfully, we see it as the speech that has caused this problem. At Unity Fest, Ms. Somerville spoke out, used a poem, and after that we see that the effectiveness of the university went haywire. We see that male applicants dropped by 20%. We see legislatures and donors pulling out their funds of the university. Respectfully, Your Honors, without money, this university—
I guess my question is, were they doing that because she read a poem, or were they doing that because they now realized that the applications process was favoring men?
Would you repeat the question?
Sure. Are the complications that the university is experiencing due to her speech, or is it people reacting to the perceived misogyny in the school?
It is a little bit of both, Your Honor. However, it's heavily dependent on the speech. Before her speech, Your Honor, this campus had a problem. However, that was mainly a problem not related to the case at Barr. It was racism, but not affirmative action. It was essentially racism. But after her speech, Your Honors, as we can see, males even felt that they could not even apply to school anymore because they felt that they were being sheltered. Page 10 uses, I think, affirmative action babies. So it's not the policy that is the problem, it is the speech that Ms. Somerville used that is the sole problem.
Well, earlier you were saying she's airing her personal grievance in the classroom, and now you're talking about the speech. So airing her personal grievance in the classroom, while that may not be a public concern, wouldn't that be within the academic freedom for the classes that she was teaching?
Respectfully, no, and this goes to my first point. Opposing counsel relies heavily on an academic freedom argument. However, when we turn to the cases that opposing counsel uses, those are lower court cases, they are not binding. True academic freedom, as this court has stated in Sweezy versus New Hampshire Supreme Court case, as cited in Regents of the University of California versus Bakke, another Supreme Court case, they gave true academic freedom to the universities. They called it the 4 essential freedoms, as they wrote that it is the business of the university to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. Academic freedom is the freedom of a university to make its own judgments on education. They go even further to write in Urofsky v. Gilmore that academic academic freedom is not even a constitutional right. In fact, in Brown v. Board of Education, they wrote, teachers are subject to consequences as well. Thus, when Ms. Somerville made her volatile comments, the university was well within their right to fire her. However, even if we want to use the lower court cases, there are a few key differences that we must make between these cases and the case at bar. Both Adams and David Demmer's speech did not have a direct effect on both the campus nor the university, unlike Ms. Somerville's speech, which had a direct negative effect on both campus and the university's operations, with the examples I provided earlier. Donors and legislatures pulled out on page 10 of the record, and mail applications were down by 20% as well.
As for her speech, and none of that happened after her classroom's speech, did it?
What, Your Honor?
The negative effects you're talking about.
The negative effects were after her classroom speech, Your Honor.
Right, but the university didn't suffer any negative effects until after the public speech that went viral, isn't that right?
Correct, Your Honor.
And don't you characterize that speech as citizen speech?
Respectfully, no, Your Honor. Although it was a matter of public concern, Ms. Somerville made her comments as a direct employee of this institution. On page 8 of the record, it states that when Ms. Somerville spoke at Unity Fest, she addressed herself as a lecturer of the university, and thus she put on her employee's cap. Thus, her speech is not protected under the First Amendment. In addition, it is our contention that Ms. Somerville was paid to work with student groups such as the one that put on Unity Fest, and thus she was definitely speaking as an employee and not as a citizen, Your Honor.
How did that speech make the university less efficient in providing public services?
Well, Your Honor, as we see here, the university and university as a whole are businesses, and the operations were hindered when money is taken out of the system, as we can see here today. Now, the full effectiveness of the operations were not at bay. However, this court has written in Pickering v. Board of Education that the government must have just adequate justification to treat her differently from any other member of the society.
Did they have less students as a result, or just less male applicants?
They could potentially have less students, Your
Or
Honor.
did they?
No, Your Honor. However, applicants do turn to students, and thus, if we don't have enough applicants, we are not meeting our goal of adequate diversity.
Is that in the record, though, that applications dropped overall?
Footnote 4, page 4. Wait, sorry, Your Honor. Did applications drop overall?
Yes.
After the speech?
That's my question.
Yes, Your Honor. On page 10 of the record, it states that, only law school applications dropped. However, the law school and the university Oklahoma State University are the same legal entity, and thus they are essentially in the same application process. Thus, applicants are, as a whole, have dropped, Your Honor.
And I guess my question goes more to the students, the number of students. I understand that there were less male applicants, but did the school compensate for that by admitting more female students to maintain its student numbers?
Yes, Your Honor, they did.
So
Yes, Your Honor, they did.
was there a loss of finances in this specific instance?
No, Your Honor, when it comes to total students, the numbers did not drop. However, based on the facts of this case, it is deemed that donors and the university needs outside funding in order to function, and the state was pulling their money, and thus that is the reason that Ms. Somerville's comments were taken in a negative tone.
Isn't there a freedom to speak when you see a state entity is doing something that you believe is wrong?
Yes, Your Honor, that is what the freedom of speech was.
And wasn't Ms. Somerville herself an applicant at the law school who was denied because of this policy?
Yes, Your Honor.
So are you saying that she can't speak as a citizen because she was denied her application was denied at all?
Correct, Your Honor. Opposing counsel states that since she applied as a citizen, she is allowed to speak on whatever, she's allowed to speak on this subject matter. The fact is that as an employee of the university, when she spoke, she was a direct employee of this university.
Is there ever a time where she could speak and she's not an employee, she's not speaking as an employee, but she's speaking as a citizen?
Yes, Your Honor, there are.
How would you just differentiate that?
I would say at Unity Fest, had she not identified herself as a member of the university, that would have been totally acceptable. However, the fact that she identified herself, and thus there were many students that could have possibly thought that she had a direct connection to the university, then public institutions must be able to shield themselves from controversial comments that have a direct effect on its operation, Your Honor. In conclusion, as noted in previous decisions, this court has found speech relating to matters of personal interest to not be protected under the First Amendment. Petitioner, as a professor at OSU, spoke out on a matter relating to her personal interest in a classroom setting which makes her speech unprotected by the First Amendment, and thus we ask this court to affirm the ruling of the lower court. Thank you, Your Honors.
Your Honors, with the brief time I've been allotted, I would like to address one 14th Amendment, one First Amendment issue. Your Honors, opposing counsel contends that the policy is not a violation of the 14th Amendment because the school has an important interest of diversity, but this is simply not the case. In order for diversity to be a compelling or important governmental interest, it must be meaningful. And as stated in Regents versus California versus Bakke, the court defines meaningful diversity as, quote, not being an interest in simple ethnic diversity in which a specific percentage of the student body is in effect guaranteed to be members of a selected ethnic group that can justify the use of race. This is exactly what OSU is doing in the case of Barr. They implemented a policy for the sake of statistical diversity that isn't remedying any discrimination or dire need for meaningful diversity within the law school. Now transitioning to the First Amendment component. Opposing counsel contends that Ms. Somerville is speaking in her capacity as an employee, not a citizen, and that OSU, as a result of the speech, went quote-unquote haywire. First, as stated in this court in Pickering versus Board of Education, in the facts such as the present one, in which employment is only tangentially and insubstantially related to the subject matter, it is necessary that we regard that teacher as a member of the general public he, or in this case she, seeks to be. Your Honors, teachers are not constitutionally compelled to relinquish First Amendment rights as a virtue of public employment, even in the realm of academia. And furthermore, as opposing counsel states that OSU's campus culture went haywire, it is important to note that it was already haywire as a result of systemic misogyny, racism, and anti-Semitism, and Ms. Somerville's speech aimed directly to remedy this public concern. It is for these reasons that we urge you to decide in favor of petitioner. Thank you.
I guess I'll start. Heather, I thought you did significantly better. That was huge improvement. I was really impressed. You did a great job. You had much better projection with your voice. Just, I could hear you better. You spoke more clearly. You seemed a lot more confident. Very good job there. You didn't apologize. Good job on that. And I thought your answers were really great. I think you really understand the issues and you can express yourself very well. There were times in your answers that I wanted you to go a little bit farther in your answer. There was one specific case that you were talking about. I'm going to try to remember the exact context. It's been a while. But it was the Michael versus Superior Court case where we were talking about the differences in that case and the case at Barr, and you were talking about how the genders were similarly situated in this case because it was a university, and I kind of wanted you to go a little bit farther and explain what Michael versus Superior Court was about. That was a rape case, and you can explain to us why they were not similarly situated in that case, because women can become pregnant, and among other things, biological differences and things like that the court touched upon in that case. And I think that you could have made that point just a little bit stronger by talking about the facts of the case a little bit. I thought you did a really good job defining what critical mass was. I think that's the first time I've heard somebody actually say what critical mass is. I guess the judges will probably know, but it was kind of something that I haven't heard in a long time, so I appreciated that you went into it a little bit more. That's the bulk of what I had.
Yeah, so we asked you a few questions, right? And what I don't want to see is you wait after you give me an answer. So
Okay.
you give me an answer, then you'd like wait to see if it was good enough.
Okay.
Don't do that.
Okay.
You'll give me an opportunity to ask a follow-up. You'll give her an opportunity to ask a follow-up. Get right back to your point. And you did that a couple times. Easy there. I tried to throw you a couple softballs to see if you could handle, how you would handle those questions, because you seem to be able to handle the confrontational questions decently. I feel like you dropped my softball I gave you on, like you almost started arguing against it when I didn't take my softball with other options. Oh, weren't there other options that they could do instead of the admissions policy? And it's almost like, well, they already have, and I'm like, wait a minute, that's against your point, and then you switch. So just get a little better. Sometimes the judges actually want you to succeed. And so they give you a softball, be able to grab it and run with it. Yeah, I like you gave the issue presented, 2 reasons they violated, mutable characteristics, doesn't meet the goal, a good argument structure. Sometimes we all struggle with stumbling over your own words. Some of the ways that we do this is, well, the boy, girl, you give like a visual head shake and then like get back, it's like you're reprogramming, recalibrate, get back to my point. All of you could work on that polishing of your argument. Just careful with stumbling over the words. If you're speaking too quickly, slow down so you don't stumble over your words, whatever you need to do.
And don't react to it or call attention to it.
Right, that's exactly right. But good time management with the wrap up, you watched your clock, you saw what was happening, so you switched, and did you wrap up and nailed it. So good job. Yeah. So Sarah, also good job. Good introduction. I couldn't write down what it was, but I was just like, wow, what a good introduction. I watched you more this time, and I was taking less notes. I didn't even realize the first time. You had that memorized, didn't you?
Yeah.
I couldn't even tell it was memorized the first time. It was so just conversational that when I was watching you, I was like, holy cow, she's got it memorized.
Thank you.
Amazing. So that's 2-edged compliment. It's good job having it memorized because you got it down cold. And then 2, the compliment is it doesn't sound like it's memorized. So good job. You slowed down your speech. You made it a little less, so you slowed it down. Good job. Excellent control of the room. Oh my gosh. I mean, we're in your house right now. When you were up there, I was just like, am I allowed to talk? I mean, you just had control of the room. And that's right. I mean, so when I have trials, whatever, I get there early usually, if it's a new courtroom. And I walk around the courtroom and I say, this is my house.
This is my house.
This is my house. And you flex that a little bit. You walk around, you're like, this is my house. This is where I sit. I'm comfortable right here at that podium, whatever, right? And I felt like you were comfortable. Did I catch you say Demers versus Austin though?
Possibly.
There's no Demers versus Austin
Yeah,
case,
I
is
know.
there? It's Demers versus Brown?
No, it's Demers versus Austin. Yeah.
Oh, it's Demers versus Brown.
Brown versus Board of Education.
No. There's that too. But... Okay, well, never mind.
Are we going back to
Demers versus Brown. All right. Well, I have a Demers versus Brown case.
Oh, you do? Where is that?
Right here.
Yep, that is what it says.
In the bench brief?
And so
That's
Is
not,
that a separate case?
Well, this is,
so,
Ninth Circuit, 2014.
that's literally Demers versus Austin. I could like look it up and
That is hilarious, because I wrote down, Demers versus Austin, is that a mistake? Isn't it versus Brown?
I can like guarantee you it's Austin, like not Brown.
Yeah, I'm not saying that.
Yeah.
Google doesn't have a Denver.
Okay, yeah. So in the table, so in the record, so it's like Denver versus Austin and Brown versus Ford.
You're so good, you're catching mistakes in the bench freak. Okay, well, good job. I love the dark day for this court. Good conclusion, really impressive overall. Great job.
Thank you.
I thought your conclusion was phenomenal. I thought you really ended on a great and strong note. Sorry, now I'm looking for Demers versus Austin.
It's alright, I'm just gonna exit out Austin, not Brown.
I should have emailed.
So I think I like your pace. It is really fast. Like he said, you slowed down. I still felt like it was super fast, but I don't know how you're gonna get everything in there with us asking questions unless you speak fast. So I think I decided that I do really like your pace. I really liked just the legal language you used, focusing on lower court trends, things like that. I think I wrote down a couple other places, but I can't find them. But I thought that you had a good command of just legalese in general. It didn't seem like an undergraduate giving those arguments. It felt like a law school student, a lawyer, making those arguments. So I thought that was really good. I really liked that you pointed out that the gender tension had been ongoing for years, because that really undercuts their argument on the detrimental effect. And I think that's a really strong point. I don't really have anything negative written down, so good job.
Thank you.
Your tiny little quirk when you misstaked was like very subdued. So it sounds to me, it looks to me like you've worked on that. You still have the human nature of when you misstate, kind of do a little, oh wait, hold on. But it was so slight compared to some of the other people. But that's not really a critique, that's actually a compliment. But you can always improve that.
Yeah, thank you. I really appreciate it.
I know that you're probably aware of this because you're obviously working on it and not doing that, but because you had it so memorized, I am a little worried that you're gonna come across as scripted and robotic, and just make sure you don't do that, because sometimes you end up doing that after you've been through it 3 or 4 times. So just be aware of that when the actual day comes, but I think you're gonna be fine in that regard.
It's like ingrained in our souls at this point.
Yeah, exactly. Dani, I love that you keep pointing out every single time that she was below average. No, I think that's a good point to make, and I think it's good that you make that point. And you do it in a classy way. You're not being snarky about it.
Yeah.
So I think it's worth saying that. You have great structure for your arguments. You have really good answers to questions. I thought that you did a much better job of talking about the imbalance and concerns about the concerns that the university would have in less male applicants. And I think that you walked that line very well, focusing more on imbalance rather than oppression. And so they just don't want to see a gender imbalance again. And I thought you did that really well. So that was an improvement. And I thought you did a good job going into the cases with plus factors, and you had a good command of what the cases were saying about plus factors. Only main criticism I wrote at some point, and I don't even remember the question now, but I wrote that I didn't understand your answer on the question about US versus Virginia.
Yeah, I don't actually use that case in any of my arguments, so like I didn't think judges would bring them up if I didn't use them to make any argument, so I just like I wasn't as like knowledgeable as that case, so I don't use the precedent at all in my arguments, so I was just not
Maybe
familiar.
just make sure you're familiar with that case,
Yeah.
just in case it does come up, because you sounded good and you looked good saying it, but I didn't understand what you were saying.
Oh, I didn't know.
I'm
I
sorry.
just started saying
But
stuff.
you
I don't
sounded
even
like
know what I
you knew what you were
said.
saying.
That's what we're supposed to do. but-
I literally just, I didn't know what I was saying. I just kept going. So, what I do.
Okay, you got a little tongue-tied at first, not a big deal. That's kind of what I was trying to say, all of you kind of did a little bit. You had a good structure of the argument, that was something I wrote down. Your academic freedom for the university argument, that obviously, Jeremy, you used as well, really good.
Yeah.
You take one of the best arguments that the petitioner has and use it for your own purposes, which I thought was fantastic. I wrote excellent mastery of the cases, in the cases. Okay, so you didn't just know the case, you knew the cases in the cases. Excellent. The one question I had regarding exceedingly persuasive, and you quoted that to be from what case?
I think it mentioned it in the case of Wen versus INS.
Yeah, you did, okay. And I didn't see it in that case at all, but I don't have a full case, I just have like the summaries. I would have gone
Yeah.
through the Virginia case, cause that uses it, and so does
Yeah.
Kirchberg. They
There's
both
a
use
few
that.
cases that
Okay.
will mention it,
Okay.
and so because I only like look really at the cases I'm making arguments for, I will use the language. I usually use the language.
I didn't, so just double check that,
Yeah.
yourself, and
Yeah,
make
of course.
sure that that
It's-
actually is in that case?
Yeah.
Okay, it's just not summary. It's hardly worth mentioning, one of your slight nervous tics is a laugh or a giggle. I mean, it's hardly worth mentioning, it's
No,
just,
it's okay.
it's not a big deal.
I do that a
Check mark on holistically reviewed, that was something I wanted to talk about, and check mark on the conclusion was fantastic. So, that's all I got.
You wanna start on Jim?
Yeah, sure. Jeremy, I don't know how much was memorization that you just don't have cold yet, but you definitely need to work on getting those words out in an eloquent manner and not get them caught right here in your teeth. So get those words out. You're probably the worst culprit in the shaking your head when you misspoke. All those little things, I don't know if it's nerves, I don't know if it's just because you don't have it down well enough yet, I don't know. But I'm sure you know how to fix it. It's one of those two things probably. So work on that. I like your personal grievance aspect of it, because the grievance is in one of the cases, you know, where it's a grievance, then it's not a public concern yet, so I like that. Let's see. Good wrap up, good time management. I didn't see, so we kind of threw a curveball at you regarding applicants as a whole had dropped, and you tried to say they had, and I don't think that's in the record. And so she kind of gave you a way out of it, and you took it, so good job. You don't want to get caught saying things that are outside the record, so. That's it, that's all I got.
So I thought overall you had good composure, good tone, good voice projection,
Mhm.
okay? You did stumble over your words occasionally. I think you'll iron that out and it'll get a little bit smoother on your delivery. I thought you had some really great answers for some hard questions, and I was impressed with that, even when the answer wasn't particularly good for your side, you did a good job of redirecting to something that was good for your arguments and redirecting to a case that did support you. And I think that's really important. So good job on that. I especially thought that your part on academic freedom was really good. I really enjoyed those arguments, so good job on that. Main thing that I would have for you, you seem to have a good knowledge of the cases and your arguments, is just iron out your delivery just a little bit more and make it a little bit more polished.
Yeah, I concur with what she said. I had written down the academic freedoms reserved for universities, not professors. I kind of took what Dani was talking about and you kind of ran with it. Now, obviously, I don't think it was impromptu. You probably already were planning on doing that. Really good arguments.
And on your rebuttal, Sarah, I thought it was amazing. You did a great job. Rebuttals are really hard and intimidating. And I
back
get
up there.
intimidated whenever I have a rebuttal because you have to really think on the spot and you can't really prepare ahead of time. You have to listen to what the arguments were actually made. And I thought you did a good job of actually quoting the arguments that were made. So I just wanted to point that out. It's good.
Is that true?
Pardon?
Did you actually form your rebuttal based on the arguments presented to you, or did you already have it planned out?
So I had hers already planned out, but I already just wrote mine out, like as I was listening to his. But, I mean, it's like the,
Seriously?
yeah.
I wrote down, memorized. Doesn't sound memorized. Again, I thought that was canned. I thought you had that cold. I did not realize actually that you had drafted it while listening. I just thought it was just a really good wrap-up rebuttal. So,
Thank you.
yeah.
I was really impressed tonight, guys.